Okay, so we're back on the S.45 Committee of Conference, and after taking a little break and reviewing the language, which we appreciate your working on for us, we met and reviewed it, and we've got a couple of suggestions to I want to say improve it from our perspective, improve it, and maybe put it on the line. And you have a
Yeah, I'm happy to play it. On the number two, C2, the one change that we proposed is instead of sole cause, proximate cause, which is a well-known standard in law. It is admittedly harder to show sole cause than proximate cause. But otherwise, having that objective evidence makes some sense, particularly if you're looking for an effect on health. So that one, relatively straightforward. We have a little more substantial suggestion on number 3. It just having to show noxious or significant interference based upon objective documented medical and scientific evidence seems to be a very high bar. And what we would propose is the following. We would strike the based upon objective document, the rest of that sentence, and we would propose a reasonable person would find that the agricultural activity was a proximate cause of the noxious and significant interference with the use and enjoyment of the property. It is still has some subjectivity in it, but the reasonable person standards, I think Rob can tell me, is a well understood standard in courts, and it does it makes it less subjective. I'll turn it over to you if you want to
read that again.
Yeah, I'll start. Go ahead. So a reasonable person would find that the agricultural activity was a proximate cause of the noxious and significant interference with the use and enjoyment of the neighboring property. And part of it is, we don't have a lot of case law that's applied this, but from my understanding, the Roosevelt case, Judge Teachout, it wasn't clear that they were applying a reasonable person standard to determine that something was noxious. And I think that whether that would have changed the outcome, who knows? But anything more on that?
No, I mean, I think the reasonable person standard is a known standard that courts have experience implementing, and it raises the standard above a subjective determination. May be based in part upon evidence, but it's going to have to be more objectively sufficient to meet the reasonable person standard.
I guess I would ask what you gentlemen think about. I can't say that I'm all happy about it, to be quite honest. I don't know why we don't want to offer those protections to our agricultural community. I don't know why we should have a bar lower than what it should be presently, but if my 2 fellow senators are willing to go along with this, then so be it. But I just, we agreed with everything that was put forth. We came up with another, what I thought was a good compromise. And once again, there's more leverage being placed on somebody going after agricultural specialists as far as the farmer being able to prove that level of, but I'm not the legalese here. Senator Plunkett is, so I will yield to him on this particular one here, but I just don't know why we keep going down this road.
Yeah, I suppose I'd ask, actually, I guess I'd ask if we could take a brief recess